All right, hello class. Professor Collins here. As I've said many times before, that this class isn't stagnant. It's not the same. It changes from time to time. And one of the things we've looked at when I first took over teaching this 12 years ago was the U.S. Patriot Act, Foreign Intelligence Act, and electronic surveillance. And it's an investigative resource that is used, especially electronic surveillance, used in a wide range of investigations, not just, domestic intelligence or counterterrorism type of situation. It can be used to prevent crime, monitor a person or a place for 24 hours or 7 days a week, collect evidence for court, and to protect a home or business. Electronic surveillance is subject to local, state, and federal laws, and is considered a search under the Fourth Amendment. Excuse me. This means that it is subject to the same warrant requirements as other search warrants. In addition, it is illegal to record someone without their consent where there is an expectation of privacy. This doesn't count for surveillance cameras in public places or in privately owned buildings with a shared space. So, and it really kind of narrows down to bedrooms, bathrooms, and changing rooms. All right, there's something called the misplaced reliance doctrine. And this is, no warrant is required to obtain information from a conversation that can be overheard by police or their agents, based on the subject's misplaced reliance of the expectation of privacy, which means, as an undercover or a confidential informant could put on a recording device, basically known as a wire, and go and engage you in conversation about illegal activity. And if you're, naive enough to discuss it, you don't need a warrant for it. And this complaint, wearing an electronic listening device or a recording device, which happens a lot in undercover operations. So also, it could be done on the street. I know many times with high-profile non-fatal shootings, they will put undercovers into the crowd to kind of gather information from the crowd of what people are saying. And they've also put undercovers into holding cells with suspects to see if they can get any information from them. All right, electronic surveillance is the use of technology used to gather information about a person or place without their consent. Wiretapping, bugging, videotaping, geolocation tracking, data mining, social media mapping, internet and data monitoring, email tracking, and remote PC surveillance. These are all things, and believe me, this is when I first started teaching this course, the idea was basically a lot of what was case law and state and local and federal laws were related to the telephone hardline, which was the only technology in those days. All right, Title III, is Title III, the Omnibus Crime Control and Safe Street Acts of 1968. Now we go back once again to the 60s. And it's also known as the federal wiretap. It governs the interception and use of wire, oral, and electronic communication. So it kind of covers that whole gamut of today's technology. Government officials must obtain a judicial warrant to intercept communications. And this warrant is only good for 30 days and requires the showing of probable cause, as you would in our other search warrants that we studied. Prior to this, it was only related to the federal government, prior to 1968. So local law enforcement, state law enforcement, could basically intercept phone calls. Very, very not so sophisticated technology. You would go into the building where the phone is. There used to be a phone box with all the connecting phones, and you would tap on to whatever wires and take that information off. The scope depends on the crimes being investigated. State officials can investigate a wide range of crimes: murder, kidnapping, drug trafficking, firearms trafficking, criminal organization situations. And federal law enforcement can intercept electronic communications for any felony. For oral or wire intercepts, there's a specific list of crimes. So as we're seeing now, I've stressed it before. In today's investigation, we're looking at computers, hard drives, emails, text messages, cell phone data, social media. It's a wide variety of things that we have kind of put out there and had our privacy taken away from us. It's the convenience of technology, but it also kind of really violates our Fourth Amendment rights in a lot of ways, but we don't have that expectation of privacy. All right, Title III protects the privacy of oral and written communications and imposes strict requirements on district courts. As I said, it's like, monitoring the wiretap progress, ensuring wiretap necessity, and confirming compliance with all of the parameters of the Title III. Wiretap requests must contain a statement that other investigative measures have been tried and failed, and this is why they need to succeed. And I'll go back and give you an example. A number of years ago, when I was working with the Bronx District Attorney's Office, a young woman came in to report narcotics trafficking on the East Coast, coming from Puerto Rico and Arizona into New York, and then distribution down in Wilmington, Delaware. Her brother had been involved with this drug trafficking organization. He got arrested. They promised to take care of the family, and they didn't. So now, in scorn, she came in willingly and gave us a lot of information for it, which we did almost a year's worth of investigation. Now, fixed surveillance, mobile surveillance, records checks, everything we could, but we could not, get enough enough evidence for probable cause to go up on a wire until the main subject in this investigation asked her to bring a shipment on the Amtrak down to Wilmington. She saw the shipment, gave us that information. Bingo, we got what we needed for probable cause, and got the wiretap. Once we got on the wiretap, it was like hitting the jackpot. It branched off into several different electronic surveillances down in Delaware, out in Arizona, and we had to get the Drug Enforcement Administration involved. So, this Privacy Act was amended in 1986 and extended to protections of Title III to all electronic communications. As I said, we saw that they were moving on with the technology and what you needed to do. And it says, all right, the Foreign Intelligence Surveillance Act of 1978. Like Title III, the FLSA legislation resulted from congressional investigations into intelligence surveillance conducted in the name of national security. Provides judicial and congressional oversight over foreign intelligence surveillance while maintaining national security. That's in 1978. You're coming up with the Munich Olympic terrorist attack, various terrorist incidents throughout the world, and also international spying, which had been going on prior to the Second World War between Russian intelligence, British intelligence, United States intelligence, French intelligence, all over the world. So it provides. It was enacted in 1978. It was designed to monitor electronic communications, but has since been amended to include physical searches and business records, which we'll look at. All right, the provisions: electronic surveillance on activities of foreign governments and their agents controlled by the Foreign Intelligence Surveillance Act. It authorizes a small group of federal judges, it has to be federal judges on the federal level, to issue warrants for wiretaps and other surveillance activities. The Foreign Intelligence Surveillance Act was amended by the USA Patriot Act in order to give federal agents greater power to conduct surveillance of suspected terrorism. All right, we've already looked at international terrorism as actions that involve violent acts or acts dangerous to human life that are in violation of criminal laws in the United States or any state or that would be a criminal violation if committed within the jurisdiction. Once again, we're going to stress here jurisdiction of the United States, and any state or any state appeared to be intended to intimidate, coerce a civilian population to influence the policies of the government, or intimidation or coercion. Now, foreign power is what we're looking at, or any component thereof, whether or not recognized by the United States, a faction of foreign nationals or nations, and not substantially composed of United States persons. And we're going to look at why is it saying recognize, whether or not recognized by the United States. 1978, there was a lot of terrorism activity coming out of Palestine, and the Palestinian Liberation Organization had not yet been recognized diplomatically by the United States at that time, and other little factions that were going on throughout the world at that time. So it was kind of a wide range that we could, spy on foreign governments, but also entities that were coming across, whether it was the Palestinian Liberation Army or Hamas, Hezbollah, Taliban, ISIS, all of these things, Al Qaeda, all these things kind of went to it as foreign entities. And it's a group engaged in international terrorism or activities in preparation thereof. And this is basically weapons purchasing, the sharing of intelligence and information to conduct terrorism. And it's a foreign-based political organization, not substantially composed of American United States persons. And it's very telling wording in this this legislation, in that United States persons are covered by the Constitution. Foreign entities are not. So it's kind of that gray area. Agents of foreign powers, any person other than a United States person who acts in the United States as an officer or employee of a foreign power, or a member of a foreign power, or as a member of a foreign power, and engages in clandestine intelligence activities. As we're saying, I'll just keep going back to Russian spying, engage in international terrorism, various terrorism groups, engages in international proliferation of weapons of mass destruction. So people that, sell missiles on the internet and, in the black market, etc. United States person is a citizen of the United States, an alien lawfully admitted for permanent residence, an unincorporated association, a number of substantial members of which are citizens of the United States or lawful aliens. So persons cannot be considered foreign agents based solely on activity that is protected by the First Amendment. You can go out into the middle of Foley Square in Lower Manhattan and say what you want about any kind of organization. Will be surveilled, and a case will be opened up on you, but it is still protected by the First Amendment. Probable cause defined in the Foreign Intelligence Surveillance Act warrants the judge must consider the target's past activities, as well as facts and circumstances related to current and future activities may be considered. Foreign Intelligence Surveillance Court is currently consists of 11 judges appointed by the Chief Justice of the Supreme Court. After the terrible events of September 11, 2001, the USA Patriot Act was passed in Congress soon after. The act changes the Foreign Surveillance Intelligence Act, Title III, and numerous other federal statutes to facilitate detection of terrorist and stop terrorist attacks. So this covers a whole gamut and kind of changes it. It's basically uniting. It's basically giving wider range to investigate and prevent and terrorism. All right, and from that it became the Department of Homeland Security. Department of Homeland Security is federal executive department responsible for public security. It began its operations in March 1st, 2003, as a result of the U.S. Patriot Act, and its mission goes over a wide range: anti-terrorism, border security, immigration and customs, cybersecurity, disaster prevention, relief, and management. It contains 22 separate agencies folded into under one umbrella, including most of federal law enforcement, with the exception of the FBI. The FBI did not come into this. They wanted to remain independent, basically because a lot of what, they also had foreign investigations in other countries going on. All right, the Electronic Security and Privacy Act, which was enacted in 1986, has extended restrictions of government wiretaps of phone calls to include electronic data by computers, emails, text messages, social media. It's all kind of grown since 1986. And it has added new provisions prohibiting access to stored electronic data. So we have to get a warrant to go into your emails, your past social media posts, etc. And it was further amended once again in 2001 with the U.S. Patriot Act, and in other amendments in 2008, the Foreign Intelligence Surveillance Act. All right, like any other intrusion, Fourth Amendment intrusion, application for an electronic search warrant must be completed. The identity of the law enforcement officer making that application, the name of the senior officer who reviewed the application, authorized for presentation in court. In that one instance I discussed earlier, the case detective, he was he was named in the warrant. I was named in the warrant as the senior officer who reviewed the application and authorized it for presentation, and a full statement of the facts, circumstances relayed on by the application to justify the belief after that order was issued. It was also reviewed by the district attorney. And Robert T. Johnson, who was the Bronx district attorney at the time, was very, very thorough. He was a former judge. He's now back being a judge. He looked at everything as if it was in his courtroom. He read every word of the application. All right, details as to the particular offense that is being or is about to be committed, particular description of the nature, location of the facilities from which the place that the communication is to be intercepted. It's originally a group of cell phones, and then amendments were done to it as we picked up other persons of interest or suspects and subjects in this investigation. Particular description of the type of communication to be intercepted: cell phones, text, emails, social media. Got to be specific, as you would in a regular search warrant, as we learned in search warrants. Identity of the person, if known, committing the offense and whose communication to be intercepted. Usually that would be the main subject in the investigation, and then as we identify certain other suspects in this situation. All right, a full and complete statement as to whether or not other investigative procedures have been tried and failed, or why they reasonably appear to be unlikely to succeed if tried, or it would be dangerous to try. So you got to give the reason why you're going this tremendous intrusion. So a statement of the period of time for the surveillance will be maintained. Usually you get 30 days, and then you have to re-up every other 30 days. And full statement as to previous applications involving the same person, places, or facilities. Once again, if there's been wiretaps unsuccessful on these individuals or on this area, it'll probably be rejected. A judge to issue a roving warrant that allows a person follows a person rather than tethering the surveillance to one specific phone, if sufficient facts are presented in the affidavit to justify, which is what goes on today with the advent of technology. That was written in there as we were just tapping the home phone of some member of a criminal organization. If an extension of the warrant is needed, the application must comply with the requirements of the original warrant and what has been obtained during the previous warrant. So you have to turn over, to the court again what has come about. Legal authority review. Federal law enforcement agents must have their applications screened by a senior member of the Attorney General's staff before submitting to a judge. And the state would be the district attorney of the location where you're applying for it. As I said, Mr. Johnson was very easy that way. It was very thorough that way, excuse me. All right, emails and texts are considered electronic communication and when sent, and can be recorded when using the Wiretap Act or Foreign Intelligence Surveillance warrants. Messages under 180 days, access to voicemails, emails, and text are protected under the Electronics Communication Privacy Act. Law enforcement can gain access by using a search warrant. The same warrant can be secured by using the same process as any search warrant. So kind of like we went to. If the communications are over 180 days old and stored in a remote storage, the government is willing to allow a person whose messages are sought to have prior knowledge that their records are being sought. The agency can obtain a court order or trial grand jury subpoena, and the court can order a 90-day, or the court can order a 90-day delay in notification. The government does not want that notification, they must obtain a search warrant. So it's similar type of situations, except for you're not going into the device, you're going into past storage. Stored Electronics Communication Act establishes procedures for using subpoenas and search warrants for stored digital data. Emails and texts are considered electronic communication and covered by the Wiretap Act if intercepted as they're being transmitted. Stored Electronics Communication Act applies to emails, text, and other digital data stored in third-party storage. Examples, old emails by a third party. Big case on that was during, in the mid 21st century of then Secretary of State Hillary Clinton and her unauthorized emails and the investigation that went into that. Although there's no Supreme Court decisions, and remember I said that the Supreme Court will be making those monumental decisions as Warren did on individual rights with technology rights. There's no Supreme Court decision on data stored in the cell phones. There have been many lower decisions made. A few years ago, 20 years ago, you had the guy in, the individual in the squad who could get into somebody's cell phone and get that information. That would get the case thrown out today. You need a warrant to see what's in an individual cell phone. The standard is that the government must obtain a search warrant before accessing the data. For a while, you could get away with it, but now. There is a Fourth Amendment protection that should be complied with in all investigations. Like I've said in anything else, when in doubt, get the warrant. All right. Electronic Surveillance 2023. 48 jurisdictions, federal government, District of Columbia, Virgin Islands, Puerto Rico, and 44 states currently have laws that authorize courts to issue orders for wire oral electronic surveillance. New York State is one of them. The number of federal and states reported in 2022 increased 7% from 2021. So with the increase of technology, more and more of this surveillance is being done as part of an investigation. 1,274 warrants were issued by federal judges, 1,132 warrants were issued by state judges. 78% of wiretap warrants are issued in 6 states: California, New York, North Carolina, Nevada, Florida, and Colorado. So much for. All right. The average wiretap is for 30 days, as I said. In 2022, a Georgia federal wiretap was extended 9 times for a total of 287 days. This goes on, for very long periods of time, especially when you're looking at criminal organizations. I used to work with the same building as the Organized Crime Investigation Bureau, looking at traditional organized crime. They had wires going on for years. They just had to just keep re-upping them. A state wiretap in New York, a narcotics investigation was extended 8 times for 270 days. Now, criminal offenses, 51% of all wiretaps were for narcotics investigation. Conspiracy, 21%. Homicide, felony assault, 5%. And 81% of all wiretaps mentioned narcotics, with other offenses being investigated. The cost, the budgetary average of a wiretap investigation is $100,000 plus. There are no statistics to address the cost in personnel and facility management. I'm just going to go into it from my own experience. Wiretaps are a very good investigative tool if conducted properly under the warrant, but they're also very, very labor intensive. You need a number of people to just monitor the electronics. You need people in the field to do surveillance. You need people to do the computer checks and record checks that you need. So believe me, police administrators like them and don't like them. They're a blessing and a curse because of the amount of money that goes into it. So that is, basically what it's used for. Basically, large-scale investigations, as I said, narcotics investigations, criminal organizations, trafficking, terrorism. Also can be used under the public safety. And I go back to a case that occurred to us and Bronx detectives, where the Special Victims Squad had brought in a serial sex offender wanted in a number of open cases, and he was placed in a holding cell in the first floor of the area command center on Simpson Street in the Bronx. It's an old precinct that was now housed the Detective Borough Bronx and a number of specialty units underneath that umbrella. Well, nobody was in they put him in a holding cell and everybody left. He was kind of left alone in the cell, and he managed to escape with the chief sitting upstairs. So needless to say, it was a lot of attention was brought to it, and also the public safety, because of this individual being a serial sex offender. We were able to, under the public safety parameters of the Wiretap Act, you get a wiretap on this individual, and we ended up capturing him, calling from a phone, I believe, of one of his relatives, and he was calling from a payphone somewhere out in Brooklyn, and the detectives went out and apprehended him there. So it can be used for a number of things. So, as I said, it's a very, 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 when they're successful, they're very successful. And then they can also be not successful. That's why you have the 30 days. You have 30 days to prove your case here, and if you're not getting results, it's not going to be renewed. The warrant will not be renewed by the courts. So with that, and as I said, it's good, labor intensive, and costly. So police administrators try to, a lot of times, piggyback off the federal government, who has a lot more money than the state. So we had the Drug Enforcement Task Force. We also had the Internal Affairs Bureau working with us, due to the main subject's wife was a New York City police officer. I don't think we ever proved that she was involved in this, but there was. How could you not? So that was an internal affairs part of it. I don't know what happened to it, but we took down individuals in Puerto Rico and Wilmington, Delaware, and New York City, and and the feds, the DEA had the Arizona part of that warrant. So once again, like technology, electronic surveillance and what you need to conduct electronic surveillance is constantly changing. As I said, the original PowerPoints to this presentation that I began in 2013 dealt with hardline cell phones mostly, and how do technology of ancient history from which I was a part of. So, all right. So, once again, anything we need to know about that will be on the review. Have a good week.